The plaintiff has admitted repeatedly that she is denying my client parenting time. We have filed complaint after complaint after complaint for parenting time.
Just making sure that mom does attempt to facilitate that parenting time. I know she doesn't want to go to jail, court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know.
Good morning, Your Honor. Jennifer McCoy on behalf of Kayla Cotton, who's present with me in my office.
Good morning, Your Honor. Katie Kamaraski, counsel for the defendant, Ty Cotton, who's present with me in my office.
Okay, we're on the record here today. We have a number of different motions filed by the defendant that are set for hearing today. Ms. Kamaraski, I did receive your motions. I had a chance to review each one of those, as well as Ms. McCoy, your responses. So Ms. Kamaraski, anything that you wanted to present today by way of oral argument in support of your motions?
Sure, Your Honor. If I could just make a summary on the motion to enforce the order to enter the judgment of divorce. We had a hearing in November 2nd, 2023. We took pro-con testimony. On that day, the only outstanding issue was the military retirement pay. You had a ruling on that. And then we had another hearing on June 3rd, 2024. During that hearing, you indicated that there needed to be an order, which was entered on June 6th, 2024, where you gave myself and the plaintiff's counsel 30 days to enter an order of judgment of divorce. Both of us worked together. We came up with a judgment of divorce. My client signed that on June 27th, as did I. I delivered it personally and electronically to plaintiff's counsel's office. And then it appears the plaintiff and her counsel signed that on June 28th, 2024, but they did not file that with the court. I did not receive a copy of that until September 3rd, 2024. I'm asking the court to please enter that order today, and so that the property can be divided. And I know that there's a pending motion to modify custody, but that should not hold up the parties' division of their property. At the hearing last fall, they agreed that their custody and parenting time agreement was the best interest of their child. And until we have another hearing, that shouldn't be changed as far as that goes. I also asked in that motion if you would consider, because of the delay in entering the judgment of divorce, despite the defendant's good faith efforts, that the plaintiff have a reduced amount of time instead of the 6 months due to her unreasonable delay in entering that judgment to either refinance or sell the house. And I made a suggestion of July 2nd, 2025 of a date. On the 21-day objection to the referee hearing ruling, essentially in that hearing, Your Honor, my client was denied access to the hearing. He had some technical difficulties. I spoke to him. I directed him to go down to the court. He was there at the court. He was not allowed to come in the courtroom. The referee did excuse him from the hearing. However, I essentially attempted to object to a number of things the referee was saying, and my client was not able to be present for that hearing. During that hearing, the referee on 9/18 delayed the parenting time complaint hearing from 9/25 all the way until 11/13 this month. And so I was asking for a sooner hearing, which at this point I understand may not be possible. That may need to still be just heard on 11/13. Or if you could please hold the plaintiff in contempt today based on her testimony on 9/18, where she admitted that she was withholding parenting time. And then my other motions, I had a motion in limine to exclude or strike unverified evidence and a motion for a protective order. On the motion in limine, there's a number of Michigan rules of evidence, 901, 901A, 104, similar federal rules of evidence, 901 and 902. Essentially, the exhibits 3 and 4 that plaintiff filed on July 30th are new exhibits. And, you know, discovery closed last fall, Your Honor. And also on top of that, not only about the discovery issue, but though the plaintiff did not sign that motion, those exhibits are unverified by affidavit, they're unauthenticated, they're essentially a bunch of screenshots, there's no dates, there's no phone numbers. And so I was asking if you could please exclude those 2 exhibits from evidence to be heard on 11/13, and then a protective order for barring the plaintiff or either party really from filing or attempting to enter any exhibits that are unverified, unauthenticated, or undated screenshots of texts where there's no phone numbers, there's no dates, none of that. It's impossible for us to know the timeline. And so those are the things that we were asking for today, Your Honor.
All right, thank you. Ms. Dukes McCoy.
Thank you, Your Honor. First, in response to the motion to enter the judgment, as we had indicated in our written response, we did get a judgment together as the court had ordered and a uniform child support order. When I went to get front of the court approval, the front of the court did not approve that because the front of the court, the parties had opted out about a year prior. But then the circumstances had changed for my client. We could no longer opt out anymore. So we couldn't enter that judgment of divorce. And that has been made very clear in our pleadings, in my communication with opposing counsel. And so I'm not sure why we're even here today with opposing counsel asking the court to enter a judgment. I think that's legally improper until those issues are resolved, as we indicated. Furthermore, I think under the court rules that we cited in our response, as well as Thompson versus Thompson, the court can't bifurcate this. Under Yao versus Yao, the court can't bifurcate this case and enter a judgment regarding the property without resolving the custody and child support matters that are outstanding. So this is a request that the court simply cannot grant. And that's why we had asked for attorney fees, because the court, this is a frivolous motion because the court cannot grant the request that the defendant has made. And that should be, frankly, patently obvious. That's something that we had discussed. That's something that is clear from the law. And so we had asked for attorney fees and costs for having to even attend this hearing and respond to the motion. In response to the issues with the adjournment of the referee hearing, the referee may adjourn a hearing for good cause without preparing a recommendation for an order. There is no 21-day objection period to that type of recommendation, I guess I would call it, but all that the referee did was adjourn the hearing so that it could all be heard at the same time. There was absolutely no prejudice to the defendant. There's no harm to him because of that. It was, frankly, the defendant's problem that he couldn't appear by Zoom, and he hasn't indicated otherwise. So again, it's another frivolous motion that we had asked for attorney fees and costs for even having to respond to. Finally, the motion in limine and the motion for the protective order. The defendant doesn't like that we included his text messages between my client and himself, particularly one that referenced the court about him, frankly, refusing to pay child support. And so that's perfectly relevant to the pending proceedings. We haven't had any kind of evidentiary hearing in this matter. Contrary to opposing counsel's assertion, my client did not testify on the 18th. I don't think she even said anything at the hearing. So we've got a hearing that's coming up that the referee can make these decisions about what should come into evidence or not. Simply attaching something to a pleading does not make it admitted into evidence. And so the referee can decide those things. I think those are properly before him. That hearing is next week. And so again, we had requested attorney fees and costs for responding to this frivolous motion.
Okay, one question, Ms. Dukes McCoy, part of Ms. Kamaraski's motion regarding the judgment is to enforce the parenting time order. And my understanding is, based on your filing, that your client's not denying that the parenting time hasn't occurred as it was supposed to occur. And her reasoning for that is that the child refuses to go. So parenting time hasn't happened. What's your response in terms of Ms. Kamaraski's request for the court to order, which it did as part of its ex parte order, although it denied in part the relief requested. The court in that ex parte order did make it clear that your client was to abide by the parenting time order as it was in place. So what's your response to that portion of this?
My response is, Your Honor, that my client has made attempts to take the minor child to the exchange location. She's taken him there. He has refused to get out of the car. He is 14. My client has good cause for essentially violating the court order because she cannot force the minor child to go with his father. Frankly, that wouldn't be in his best interest. The minor child has gone to counseling, and we have evidence that we intended to present at the referee hearing that there has been a severe deterioration in the relationship between the defendant and the minor child. And so because of those issues, which are not yet resolved, which have not been heard, which have not been testified to, that evidence has not yet been presented. My client has not been able to present evidence on her good cause. And so I don't think that the court can yet find my client in contempt.
All right, thank you. Ms. Kamaraski, anything you wanted to say in response to any of Ms. News-McCoy's arguments?
Yes, Your Honor. I am aware that, the child support may need adjusted, but it also may not need to be adjusted. Initially, the initial recommendation from June of 2023 was that the plaintiff pay my client child support. It was a small amount per month, but she never has paid him anything. And, that was outside of the front of the court. We were opted out. And so that was never enforced. And this court should be able to enter this judgment of divorce and just simply refer this matter to the front of the court for a different number as far as if something happens different next week where they change the custody or parenting time arrangement, then certainly the front of the court can enter an amount with for child support to be paid and to who it's to be paid by and to. There's no reason why we can't enter the rest of the judgment with that modification. Why we have to continue to delay the dividing of the property, the dividing of the home, the retirement pay, all the other accounts. There's just simply no reason for it. And in addition to that, the plaintiff has admitted repeatedly that she is denying my client parenting time. We have filed complaint after complaint after complaint for parenting time. Essentially, these people, she shows up to the parenting time location and just says, he's not going with you today. And then he's like, okay, well, I love you, buddy. Hope to see you soon. And that's it. I've seen videos of this, which, perhaps I need to enter if we're going to go to this hearing on the 13th, but, again, they're admitting that we haven't heard any evidence that the child is actually really not wanting to go. As far as counseling goes, my client is the one who requested the counseling. He set up the counseling appointment. He insisted the child go to counseling. The plaintiff did not want the child to go to counseling. The child didn't want to go. And so he did go to one appointment. The child has actually missed, and this is not in any of these pleadings, but it's in one of my parenting time complaints recently. The child has missed several days of school while in the custody of the plaintiff. And he has not been able to speak to his father. I don't know how there could be a continuing relationship between the child and his father if he doesn't talk to his father and he doesn't spend any time with him. My client has a right under the Constitution and under the laws of the state of Michigan to have parenting time in custody unless the court says otherwise or takes those rights away, and that has not happened. So I don't think that my motions are frivolous, Your Honor. I would not file frivolous motions. I believe that I have reasonable cause to be filing these motions. I would ask that you deny the plaintiff her request for attorney fees for that. And thank you for listening to the motions today.
Okay. All right. Again, I did have a chance to review the motions prior to the hearing, taking that into account along with what both counsel had to say on the record here today. There are a number of issues presented. First of all, with regard to the text messages being attached to briefs and the motion in limine, in my view, those are foundational issues. Those text messages may very well be admissible if Ms. Cotton testifies that, you know, she received them from Mr. Cotton, that they're accurate representations of the conversations that they've had. Then questions as to when they were sent, whether there's other information that was conveyed in those text messages. Those types of issues to me go to weight, not necessarily admissibility. There are statements of a party opponent. They're admissible under the hearsay rules, again, subject to a proper foundation being laid. In other words, that they were text messages received by Ms. Cotton from Mr. Cotton. They'll be subject to cross-examination, and either the referee or myself eventually would make credibility determinations about how much weight should be given to those text messages. But again, subject to a proper foundation, as I've indicated, I think they would be admissible. So in terms of excluding them or some type of protective order, I don't think that's appropriate. Again, I think those are decisions, evidentiary decisions that would have to be made at the time that they're offered. But I don't think there's anything inappropriate about attaching them to briefs as potential exhibits. I think, in fact, Ms. McCoy would be required to do that to make sure that there isn't any type of unfair surprise. And the court frequently requires parties to at least list exhibits, if not provide exhibits prior to hearing, so that there isn't any unfair surprise and that both sides have an adequate opportunity to be prepared to address the evidence that is presented. So I don't think there's anything inappropriate about attaching them. I think they may be admissible. Certainly the court's not in a position to rule that they're inadmissible at this point as part of a motion in limine. So the court will deny both of those motions. As to and I'm going a little bit out of order here, but I'm addressing them in my view in order of importance. The objection to the referee's finding, again, that wasn't a factual finding, that was a matter of procedure. Given that there was already a hearing set for November 13th, in my view, that was a reasonable decision by the referee, regardless of the extent of participation of either party in that hearing. I think that was a reasonable decision by the referee in terms of conserving the resources of the court and the parties to have those matters all heard on the same date. As a practical matter, while it did result in some delay, it's unlikely that those matters would get before the court prior to that November 13th date anyway. And so again, I don't see anything unreasonable or improper about the referee's decision to move that September 18th hearing. And so the court's going to deny that motion. In terms of the judgment of divorce, I agree. I think that it would be more appropriate to have all matters settled before the court enters a judgment. I understand that's resulting in some delay, but I think, again, to conserve the resources of the court and more importantly of the parties, it's appropriate to have all matters with regard to the judgment settled so that there's some finality to it once it is signed by the court, filed, as opposed to entering a judgment that may or may not be challenged in one or more ways immediately after it's filed. So in terms of a motion to enter the judgment, the court's denying that. In terms of the motion to enforce the judgment and the parenting time provisions, in my view, that is an order of the court. We've got a 14-year-old child that's refusing to do what they're supposed to do. I have teenagers. I understand how difficult it can be to motivate teenagers to do what they're supposed to do. But this isn't a choice for a 14-year-old to make. And essentially, Ms. Cotton's allowing a 14-year-old to decide whether the child's going to obey the order of the court. And if that child was refusing to go to school, that child was refusing to bathe, if there were any number of things that child was refusing to do that either Ms. Cotton had a legal obligation to do, like making the child go to school, or a moral or ethical or parental obligation, like things like bathing or whatever it might be. I don't think she's going to let a 14-year-old make that choice and say, well, doesn't want to go to school, I guess the child doesn't have to go to school. The court order is no different than that at all. And in my view, allowing a 14-year-old to decide whether they're going to obey a court order is, number one, unfair to the child because you're putting the child in that position to make that call. That's something that the parents need to do. Again, I understand the difficulty in motivating a teenager, but there are any number of ways that you can motivate a teenager to do what they need to do. And ultimately, that's the parent's job. I also view it as really a way to circumvent the court process. If the situation had deteriorated so badly that it was unsafe or dangerous for the child to attend parenting time with Mr. Cotton, then there should have been an ex parte motion filed, and the court should have made a finding that parenting time shouldn't continue for some reason. And if the court granted that motion, then Ms. Cotton would be on solid ground in declining to force the child to go to parenting time. If that motion is denied, then Ms. Cotton needs to make sure the child goes. And by making that decision on her own, she's essentially taken all of that into her own hands as opposed to the court, which is the proper party to decide whether or not an order that's in place needs to continue to be followed. So for all those reasons, I do find that Ms. Cotton is in violation. The court is going to leave the remedy to that up to the referee. The referee's in a position to make those kind of decisions after hearing some evidence as to the circumstances surrounding it. But I think Ms. Cotton absolutely has wrongfully denied parenting time. She's taken it into her own hands to decide or let her child decide whether or not a court order should be followed. And that's inappropriate until that order is changed by an appropriate process, either by the referee or by this court. So in my view, that parenting time needs to be honored immediately. I put that in my order in August. That's been ignored. Or Ms. Cotton is going to suffer contempt sanctions. And so that's up to her. If she wants to let a 14-year-old decide whether to follow a court order, she's going to be the one that's going to pay the consequences for that. So the court finds that she is in violation. Again, I'm going to defer to the referee to determine what an appropriate remedy is for that violation. I also find that while the court denied a number of defendants' motions in this case, I think they were appropriate motions given the kind of tumultuous proceedings throughout the summer and into the fall. So I think they're appropriate questions to address. So the court is going to deny any request for attorney fees or costs related to the motion. Ms. Kamaraski, I'm going to ask that you prepare an order that reflects the ruling in the court today and either submit that with a stipulation as to form or under the 7-day rule.
Yes, Your Honor.
All right. That's all I have for today. The court will set this for another status conference in 30 to 60 days following the referee hearing that's going to take place on November 13th. The court will send out a notice of the date and time of that next hearing. And that's all I have for today. All parties are free to disconnect at this time.